Welcome to the deep dive. Today we are tackling a really fundamental tension in contract law. What happens when someone promises a lot of money, let's say $30,000, to pay someone back for years of really intensive personal service that's, already done? The big question for us is, can past consideration, which normally kills a contract claim, ever be enough to make a big estate pay up on a written promise like that?
That's exactly the tension we're diving into. We'll be looking at the doctrine of contractual consideration, specifically the usual rule about past services. But more importantly, we're zooming in on this crucial exception. It's a very specific one carved out by the Wisconsin Supreme Court back in 1925 in Sheldon v. Blackman. Our goal here is to show you exactly how the court essentially turned a moral obligation into a legally binding debt, focusing on, well, two key elements they used.
Okay, let's start with the basics then. Before we jump into the exception, what's the sort of baseline rule about past consideration? What do the courts generally say about paying for something already finished?
Right. The general rule is pretty strict. A promise that's only supported by past consideration, meaning an act or service finished before the promise to pay was even made, is typically unenforceable. Why? Well, because consideration needs that bargain for exchange. If the act was already done, it wasn't done for the promise being made now. It has to be mutual looking forward. So if I promise you $100 today because you painted my fence last summer, that promise generally won't hold up in court.
Okay, that sets up this Sheldon v. Blackman case nicely as an interesting way around that. Let's dig into the facts of there. What exactly happened with Julia Sheldon and the Wilkinson estate? What did she do?
Okay, so Julia Sheldon was the niece. She went to live with Mr. and Mrs. Wilkinson way back in 1889. And this was important. It was at Mr. Wilkinson's specific request. There was an oral agreement, a parole agreement, that if she cared for them until they both died, she'd get his property. Because of this, she gave up her own business, a dressmaking business. And the care she provided, it went on for an incredible 34 years. It was comprehensive, like all the housework, but also, and this is key, for 10 years she had to perform the very delicate task of catheterizing Mr. Wilkinson daily, plus constant care for Mrs. Wilkinson's health problems.
Wow. And 30 years into this, in 1919, Mr. Wilkinson writes up a formal document. What did it say?
Yes, he executed a written instrument. It promised to pay Julia Sheldon $30,000 when he died, and it explicitly said this was for the services she had already rendered up to that point. It acknowledged the debt and stated clearly that she hadn't been paid yet. So when he died, naturally, the estate challenged the payment, arguing that promise wasn't legally binding.
Right. The perfect setup for a legal battle. So what was the core legal issue the court had to decide?
The precise legal question was this. Was that written promise for $30,000, which specifically mentioned past services given under that original voidable oral agreement, actually supported by legally sufficient consideration?
Okay. And what rule of law did the court apply here? Can you state the full rule that creates this exception and maybe break down its key elements?
Yeah. The court basically found that when services are provided at the specific request of the person making the promise, and there's some underlying agreement, even a void one that shows the services weren't meant to be free, then a later written promise to pay can be enforced. To figure this out, the court looked at two main elements regarding the consideration. First, what was the legal effect of that void original agreement in the initial request? And second, how did the court view the adequacy of the consideration? Basically, how did they value those 30 years of intense care?
Thank you. Now, for the court's elemental analysis, let's walk through this step by step. How did the court apply the first element, the effect of that void parole agreement? The estate was arguing it was void because it involved land, right? So it couldn't support the later note?
Exactly. That was the estate's argument. Mini IRS E1 starts. The court agreed, yeah, the original oral agreement involving real estate was void under the statute of frauds because it wasn't in writing. But, the court said, that void agreement was still crucial. Why? Because it absolutely rebutted the presumption that Julia's services were just a gift, that they were gratuitous. That original request, that agreement, showed the clear intention from the start that she should be paid, and paid well, as the court noted. This established a strong moral obligation, and that moral obligation stemming from the requested service was enough to transform the past services into valid consideration for the later written promise of $30,000. Mini RS1 ends.
Hold on, so you're saying the fact that he asked her to come and care for them, even though the initial deal about the property was invalid, that initial request is what makes the difference. It turns past actions into consideration for the new promise.
That's precisely it. The request took it out of the realm of a purely voluntary act, like helping a stranger. It framed it as something solicited, something for which payment was implicitly, or in this case originally explicitly, expected. It created a kind of moral debt.
Understood. Okay, now let's tackle the second element, the adequacy of that $30,000. That's a lot of money, especially back then. The estate argued it was way too much, and maybe she should only get paid for the last 6 years because of the statute of limitations.
Right. Mini Act 2 starts. And this is where the court made a really strong statement about judicial interference in contracts. Basically said, look, courts generally won't second-guess the value parties place on consideration unless there's fraud or something like that. They looked at the specific facts here. The services were described as of so intimate and delicate a character. They specifically pointed to the years of catheterization and the intense personal nursing care. Because of that highly personal, difficult nature, the court found their value was indefinite or indeterminate or largely a matter of opinion. You couldn't just calculate it like wages for standard work. Absent any claim of fraud or duress, and there wasn't one Mr. Wilkinson had every right to decide what that care was worth to him. He could choose to be liberal in his compensation because he, better than anyone, knew its true value over 30 years. So the court essentially ratified his valuation of $30,000 for those past 30 years of service, brushing aside the statute of limitations argument for that specific promise. Mini Act 2 ends.
So the difficulty in putting a dollar figure on that kind of personal care was key. The court just deferred to Wilkinson's judgment.
Exactly. He knew what it was worth to him, he put it in writing, and the court wasn't going to step in and say, no, that's too much, given the nature of the services.
Okay, and after analyzing both elements, the void contract, rebutting gratuitousness because of the request, and deferring on the value of these indeterminate services, what was the court's final conclusion on the $30,000 note?
The court affirmed the lower court. It concluded that the written document was a valid, non-negotiable promissory note. And crucially, it was supported by good and sufficient consideration. So Julia Sheldon's $30,000 claim was allowed. Plus, they also awarded her payment for the reasonable value of her services set at $30 a week for the 4 years she continued caring for him after the note was signed until his death.
Interesting. Now, there was another argument, right? The estate also tried to say the note was really a will, an improperly executed testamentary gift because payment wasn't due until after Mr. Wilkinson died. How did the court handle that?
Yeah, they raised that defense too. The court shot that down pretty quickly. They relied on the established rule that just because payment on a note or contract is postponed until the maker's death doesn't automatically make it a will. The key distinction is when the rights vest. Here, the note was physically delivered to Julia Sheldon and accepted by her during Wilkinson's lifetime. She even took it for safekeeping. That means the title to the note, the legal right to that $30,000 debt, vested in her immediately upon delivery and acceptance. Only the enjoyment, the actual receiving of the cash, was put off until his death. It was a present debt, payable later, not a gift-taking effect at death.
That Sheldon exception is clearly powerful, but it really seems to turn on that initial request for the services. Let's test this with that hypothetical. Imagine someone spontaneously rescues their elderly neighbor from a bad fall on ice, maybe saves their life. The neighbor, full of gratitude, later writes a note promising the rescuer $50,000. Is that promise enforceable under Sheldon?
No, almost certainly not. That promise would likely fail under the standard past consideration rule we talked about earlier. While it's a wonderful act, the rescue was voluntary, right? Spontaneous. It lacks that critical element from Sheldon, the original request from the promisor. Sheldon needs the benefit to have been provided because the promisor asked for it, which creates that moral obligation and rebuts the idea it was just a freebie. Without that request, the rescue remains a past voluntary act. The later $50,000 promise looks like an unenforceable promise to make a future gift out of gratitude, not the settlement of a pre-existing moral debt recognized by Sheldon.
That makes sense. It really highlights the narrowness of the Sheldon exception.
Absolutely. And to help you analyze these situations, maybe on an exam or just understanding the law, here's a kind of step-by-step checklist based on what we've discussed. First, identify the promise. Is it based on services already completed? If yes, you've got a past consideration issue right away. Second, determine gratuitousness. This is crucial. Were the past services given voluntarily, like a gift? Or was there an original request or maybe some kind of agreement, even a flawed one, that suggests payment was expected? That's the fork in the road. Third, check for a void contract. If there was an original agreement but it's void for some reason, like the statute of frauds in Sheldon, don't just discard it. Remember, that void agreement can still be powerful evidence to rebut the presumption of gratuitousness. It shows intent. Fourth, analyze adequacy of the Sheldon factor. If the services are hard to value, really personal, intimate, indefinite, indeterminate, courts are much more likely to accept the promisor's own valuation stated in a later promise as long as there's no fraud or duress. That's the Sheldon deference. And fifth, test for testamentary intent. If payment is deferred until death, ask the key question. Did the legal right, the title to the promise, vest in the recipient during the promisor's life upon delivery and acceptance? If yes, it's likely a valid contract. If the right only springs into existence upon death, it looks like a failed will.
That framework really clarifies things. Sheldon v. Blackman isn't so much about ignoring past consideration entirely, but about finding a legal justification rooted in that initial request and moral obligation to enforce a promise for past services, especially when those services are, well, almost invaluable in a strict monetary sense.
Precisely. It carves out a space where a promise based on past acts can be binding. Which leads to a final thought for you to consider. What if Mr. Wilkinson had only formally requested Julia's services after she'd already been there for 30 years? Say he got really sick, was hospitalized, and then said, "Julia, please keep caring for me," right before he signed the $30,000 note for the past 30 years. Would that single, very late request be enough to satisfy the Sheldon requirement? Or would the court still mainly rely on the delicate and indeterminate nature of the prior 3 decades of care itself to uphold the promise? It's an interesting edge case.
Definitely something to think about how timing and the nature of the service interact. That brings us to the end of this deep dive on past consideration and the important Sheldon exception. Thanks for joining us.